Abusive Donald, and a shady Supreme Court. Welcome to Law and Society. Please subscribe. We're going to talk about two topics today. First, it is my belief that Donald Trump is an abusive person by nature. And I want to talk briefly about that. And the second is how I think our Supreme Court is being as shady as it can be with its shadow docket. So, at a speech where he was talking about how he had virtually rid Washington, D.C. of crime, he casually said, it's not completely crime-free because, when a man and when a husband and his wife have a fight, they call it a crime. Mind you, in order for it to be registered to be a crime, the police have to be called. There at least has to be a police report that has to become part of the data that he's getting when he makes that statement. So that, and when somebody makes a statement like that, that inherently says that when you read something that says domestic violence, and you read that as a husband having a fight with the wife, and you discount the fact that it is considered criminal, whether it be misdemeanor or felony, it goes to show what your state of mind is. Are you somebody who is of the temperament of the abuser, or are you somebody of the temperament of somebody who wouldn't take abuse, or are you of the temperament of somebody who is submissive and would allow being abused? And I believe that Donald Trump's entire life has been just littered with instances of him abusing his position and power. And this particular thing, at this particular time, when Jeffrey Epstein's birthday book comes out, and there's this really pubescent silhouette of a girl with Donald Trump's signature under it, you start thinking about Donald Trump in a very different way. And when you add the fact that he openly says that domestic violence is not really a crime, or for him it's like, oh, can you believe that? It goes to show that his state of mind is that of being an abusive person. I want to end that short talk about him, about Donald Trump being an abuser, with the courts aren't having it though. Neither is E. Jean Carroll, who the appellate court upheld her $83 million verdict against Donald Trump for sexually abusing Miss Carroll. Now, I want to talk to you about how to switch gears and talk about how the Supreme Court is delivering victory after victory to Donald Trump with their shadow docket. A shadow docket being something where they don't issue an opinion, and they're generally of equitable relief, and they seldom have any reasoning for it, and it happens outside of the term that is their official term. That starts, I believe, in October, and it ends in like July or June. So in the shadow docket, in the latest case, which I think is absolutely a travesty of justice, the Supreme Court has put a stay on the District Court in the Central District of California and the Ninth Circuit Court of Appeals injunction on the government carrying out its illegal raids based on a person's ethnicity, and based on a person's accent of how they speak English, or if they don't speak English, of where they congregate, and also where they work. These considerations, the district court and then the appellate court agreed, put together alone do not rise to the level of particularized, reasonable suspicion out of articulable facts that is needed under the reasonable suspicion standard that immigration agents are allowed to be which is a lower standard than what the Fourth Amendment probable cause is. And so, as a general statement, I believe that SCOTUS is abusive to the deference of the lower courts, to the fact-finding court, to the court that the dissent refers to on several instances when talking about how many people who live in Los Angeles who are Latino and who speak Spanish. On the other side, Kavanaugh's concurrence provides very little evidence other than the government's assertion, and even that he doesn't provide reference for, in justifying the government's acts. And effectively, Kavanaugh says, in relevant part, that, to be clear, apparent ethnicity alone cannot furnish reasonable suspicion under this court's case law regarding immigration stops. However, it can be a relevant factor considered along with other salient factors. Under this court's precedents, not to mention common sense, those circumstances taken together can constitute at least reasonable suspicion of illegal presence in the United States. So, Kavanaugh is saying that those four attributes that the district court and the appellate court upheld to not qualify as reasonable suspicions, and thereby enjoining Donald Trump's regime from conducting raids based on that guideline, on those four parameters, those, Kavanaugh says, that's sufficient to cause for the reasonable suspicion. And Kavanaugh reads the record to say that what the agents did fell within their rights in a reasonableness inquiry, where there has to be a reasonable suspicion and of particularized conduct that would that there is crime afoot. And so I'm trying to find the reasonable suspicion of illegal presence. Reasonable suspicion has to be particularized suspicion of articulable facts. And the district court and the Ninth Circuit says you need more than their ethnicity, how they speak, where they work, and where they gather as being reasonable suspicion. The concurrence's opinion is, no, those raise to the level of reasonable suspicion. And because there is no majority opinion in the shadow docket opinion, it's just to stay on the enjoinment by the lower courts, it effectively allows Donald Trump and his regime to keep going with those same standards and conducting illegal raids that violate the Fourth Amendment rights of people. And the government has said so to the effect when the ruling of this court came out from the lower court, that this court is not, that the Homeland Security is just going to ram things up even more. And the dissent really speaks on the impact of this order and how it terrorizes and goes against the constitutional protections of citizens, because citizens were detained, citizens were pushed up against metal fences, citizens were detained and their identity cards not taken into consideration. And that those people who were working in those areas, Kavanaugh says, can be held for a reasonable time, and Kavanaugh thinks that they were held for a reasonable time, and they fell within the understanding of a reasonable suspicion stop. So defendants may not solely refer to the factors below alone. They have to do it in combination with other articulable facts, and the dissent makes that clear. The dissent quite strongly says the government, and now the concurrence, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. So, the Fourth Amendment thus prohibits exactly what the government is attempting to do here. Seize individuals based solely on the set of facts that describe a very large category of presumably innocent people. The factors also in no way reflect the kind of individualized inquiry the Fourth Amendment requires. It doesn't provide citation for the government's assertions of the population of illegal immigrants in Los Angeles. It's a number that it makes up and doesn't provide any sort of evidence of that. The government has provided no evidence showing that its seizure were based on credible intelligence about particular employer at a particular location. So the specificity requirement is very much required here, where you have to particularly point out where you have to find articulable facts other than ethnicity. Even Kavanaugh says that, but you can use where they work, how they speak English to be part of reasonable suspicion. And that is just absurd and not up to the level of the reasonableness standard and the specificity requirements of having such conduct be constitutional. At no point in this litigation has the government suggested that it plans to change its operations. So now, with the opinion going to essentially being stayed while there's a hearing for certification of class, while the case moves forward on the merits, that the government can continue to do these stops in not just in every other part of the United States, but also where it was stopped in the Central District of California. So I would like to end this by making this statement about the Supreme Court. I have lost faith in this Supreme Court. I know now that I cannot expect sound reasoning from this court. It is a tragic and dangerous disposition. SCOTUS isn't even trying to be neutral. Its preliminary rulings in favor of Donald Trump's executive power greatly increases interim executive power while trampling on the rights of others, whether it be immigrants, for-cause nominated employees, trans service members, or career professionals doing their jobs. The equities favor parties battling the federal government, especially on matters that directly infringe on constitutional rights of individuals and American citizens in this case. This SCOTUS has thrown off the government-citizen balance by siding with POTUS on preliminary equitable decisions time and time again, without providing an explanation, which the dissent in this case makes clear. And the political and legal climate of our country requires the opposite. SCOTUS should be siding with individuals with limited resources on matters that are gray, legally speaking. Although many of the issues where SCOTUS has stayed in favor of POTUS infringe on fundamental constitutional rights enumerated in the Constitution and applies to all persons, namely Fourth Amendment and due process violations, as well as violations of the Equal Protection Clause and the Birthright Citizenship Clause. These are direct attacks, and the Supreme Court has just stayed it. And the Supreme Court has stayed any injunction that the lower courts have imposed to stop Donald Trump's regime from violating the laws of the Constitution, of birthright citizenship, of Fourth Amendment protection against unreasonable search and seizure, due process rights under the Fifth Amendment, right to counsel under the Sixth Amendment. So all of this is, just sort of snowballing into the Supreme Court, pointing in a direction that it would side with the executive, even on the merits, if it comes up on the merits. And I don't have that faith in this Supreme Court anymore, that it is going to give a win to the plaintiffs on the issue of birthright citizenship even. I mean, 99% it should, but now there is that 1% doubt. And with every one of these unopinioned shadow docket rulings that are peripherally guided by dissents and concurrences, it makes the judicial process, the jurisprudence, murky, muddy, and uncertain, which coincidentally is what Donald Trump wants as well. So with that said, I will end this talk. If you want to read the opinion, I would recommend reading the dissent and the concurrence to get a general idea of where the minds are at of at least 4 of the justices. We don't know why the 5 majority justices didn't even make any comment about it. But we are seeing here that Kavanaugh, who even makes an attempt to provide some reference, does so in a very, very skewed manner where it gives the government a lot more deference than the factual record says the government deserves. With that said, thank you. Please remember to like, share, and subscribe, and I'll talk to you soon.